let me just read you what the law says, okay? This is the law passed by Congress. Whenever the president finds that the entry of any aliens or of any class of aliens into the United States would be detrimental to the interests of the United States, he may by proclamation and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restriction he may deem to be appropriate. So when Trump said we're going to deem all those Muslims in Venezuela and North Korea, but also Chad, Iran, Libya, Syria, Yemen, and Somalia. And he said it was because of their vetting process. This is the third time they finally got it right. But he said their vetting process wasn't any good. Chad fixed its vetting process and was taken off the list. When they said this, they said, okay, that's the law. He has the right to do it. I don't particularly think this is an important restriction, by the way. None of these people have attacked us. This is not going to make us any safer. The danger is coming from within, the danger of the people, the young men who get convinced of this nonsense ideology. But he has the right to do it, and it's not for the courts to say, oh, I'm sorry, we don't like President Trump. And that's essentially what the dissent was. We don't like Trump, so he doesn't have the right to do it, even though the president does. There was also a major, this is huge decision, saying that you don't have to. Well, you know what? Let us bring on Jenna Ellis. Jenna Ellis is the director of public policy for the James Dobson Family Institute. She's an accomplished constitutional law attorney and has a background in criminal law, contracts, public policy, leadership, and ethics. She appears on all over the place, but happily she appears here, and she has her book, The Legal Basis for a Moral Constitution, a guide for Christians to understand America's current constitutional crisis. Long time no see, Jenna. It's like
I know we're BFFs now. Thanks so much.
It says you and me. We're like this. Well, it's been it has been a busy week at the Supreme Court. We have to talk. Let's talk first about this latest decision about public sector unions. Can you explain what they decided?
Yes. So this is the latest in the compelled speech cases, regardless of whether it's over an abortion pregnancy center, whether it's about union workers, whatever the context. This case in Janus was another compelled speech case, and where the Supreme Court, through Justice Alito, and again, like you said, that very slim 5-4 majority, saying the government cannot compel you as an individual to participate in or subsidize speech that you fundamentally disagree with. So this particular case was in the context of union workers who were forced to subsidize union representation that they may disagree with. And that was the central issue in Janus. But again, this was just a long line of cases this week, actually, and also following the Masterpiece Cake Shop case that really stood for the principle that the First Amendment is valid and that the government is not going to tell you or me what speech we have to participate in and what things we have to advance.
So basically, before this, if you got a job, say as a teacher, and you joined the teachers union, and the teachers union was using your money, you had to pay them the money. You had to be in the union to work, and they used that money to support candidates you didn't like. There was nothing you could do about it, right? But now you don't have to. Do you not have to join? Is that what it is? You don't have to join the union now?
You don't have to pay the fee.
You don't have to subsidize. Okay.
Yeah. So this overturned a 1977 precedent that had upheld a similar law, basically saying if you were part of this collective bargaining agreement, you didn't have a choice and you had to pay the union dues. And this is saying that payment, that contribution is speech, and the government can't compel you to essentially support the collective bargaining agreements and any other form of the union that will contribute to speech that you fundamentally disagree with.
And I mean,
which is a great ruling.
But it's a huge deal because these teachers unions, most of these public sector unions are big Democrat funders. I mean, all this money is going right from the pocket of teachers to the Democrat Party. Is that not fair to say?
Yeah, and this is why a lot of the headlines that you see today is the Supreme Court strikes a blow to unions, or we saw in the National Institute of Life and Family Advocates, the NIFLA case that was just handed down yesterday. The Supreme Court favors the pro-life movement over abortion rights. That's not true. What the Supreme Court is doing is simply applying the Constitution faithfully and accurately, like an umpire in baseball. They're simply just calling balls and strikes fairly. They're not actually saying we like unions or we don't like unions. What they're saying is that the Constitution does not give the government the ability to compel speech in these particular contexts. And that's actually a good thing. So it's not them picking and choosing winners and losers. It's not about whether or not they like unions, whether or not they like pro-life pregnancy centers, whether they like abortion rights. This stands for the proposition the government cannot compel speech.
Now, for a long time, the Supreme Court has been really good about the First Amendment, very strong on it. But Elena Kagan, I think it was today or yesterday, when this decision came, she accused them of weaponizing the First Amendment. I mean, as far as I'm concerned, they can nuclearize the First Amendment. They could just blow all restrictions on free speech right off. But what is she talking about? What is her point of view there?
Yeah, and this is in the Janus dissent. And what's so ridiculous is that the left is making an emotional appeal because weaponizing sounds like a bad thing. And so to weaponize the First Amendment, it's basically saying, oh no, the government isn't going to compel you to now participate in all of these things that actually advance the leftist causes. So that's basically weaponizing us to go out and support the speech that we deem appropriate, that we, the people, can actually participate in speech that we want. So her term of weaponizing really is saying the First Amendment is going to protect you in the way that the Constitution actually intended. She's just using a really negative term.
That's very disappointing from Kagan because she is a little smart. I mean, Sotomayor I think is kind of a knucklehead, but Kagan is a smart woman, and it's sad to hear that from her. Now, on the case of the anti-abortion clinics, these are emergency pregnancy clinics in California that want to encourage you not to have an abortion. And California said, well, you have to tell them that they can get an abortion. And the Supreme Court said, no, that they don't believe in that. They don't have to say it. What about the argument that there are laws on the books that compel abortion clinics to tell you that you don't have to do this? Is that covered by this law as well, by this decision?
Well, so there's a difference here between giving women all medically sound information about a medical intervention. And that's what Alliance Defending Freedom argued in this case, is that there's a difference between saying if you want a medical intervention, which is an abortion, because if a woman is pregnant, unless something naturally happens where they miscarry, abortion is always a medical intervention. An abortion doesn't happen naturally. So if you are going to get any elective procedure, then doctors always will give you the adequate information so that you can make a sound decision. And so what basically the difference is if you go to a pro-life pregnancy crisis center and you're saying, I want to be here to talk about all of this, then what the California law was doing was trying to compel those providers to say, well, one of your options is a medical intervention when that's actually not related at all to their healthcare decisions. So that's a fundamentally different circumstance in those equations. But this particular case in NIFLA talked about how a pro-life pregnancy crisis center does not have to refer for abortion. So Andrew, this would be the same thing as if, we were holding an Alcoholics Anonymous group, and every single person who came through the door, we had to have these big placards, we had to have brochures, we had to inform them, here's where you can get state-funded alcohol down the street. That's what this was about.
Well, yeah, Jenna, thank you so much for coming on. I really appreciate your putting this in the context of the First Amendment. I didn't quite see that connection, and it really is. It's good. It's excellent news. It's too bad it's only a 5-4 margin, but hopefully it'll get bigger over time.
It is. And this is why the midterms matter. We have to keep a really good Senate that will approve the next, hopefully, Trump nomination to the Supreme Court. And this is encouraging, but you're right. It's a very slim margin.
Jenna Ellis, thank you very much. Director of Public Policy for the James Dobson Family Institute. We'll see you again soon, probably.
Sounds good. Yeah, anytime.
All right, thanks. I didn't even actually think about that all of these are covered by the First Amendment.